5 seconds to go. Start. This court held that the word ground in section 227 CRPC did not mean a ground for conviction but a ground for putting the accused on trial. In P. Vijayan versus State of Kerala and another, after extracting section 227 CRPC, this court in paragraph number 10 and 11 held thus: if two views are possible and one of them gives rise to suspicion only as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage he is not to see whether the trial will end in conviction or acquittal. Further, the words "not sufficient ground for proceeding against the accused" clearly show that the judge is not a mere post office to frame the charge at the behest of the prosecution, but has to exercise his judicial mind to the facts of the case in order to determine whether a case for trial has been made out by the prosecution. In assessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into a weighing and balancing of evidence and probabilities, which is really the function of the court after the trial starts. At the stage of section 227, the judge has merely to shift the evidence in order to find out whether or not there is sufficient ground for proceeding against the accused. In other words, the sufficiency of ground would take within its fold the nature of the evidence recorded by the police or the documents produced before the court, which ex facie disclose that there are suspicious circumstances against the accused so as to frame a charge against him. In paragraph 13 in P. Vijayan's case Supra, this court took note of the principles enunciated earlier by this court in Union of India versus Prafulla Kumar Samal, which reads thus: that the judge, while considering the question of framing the charges under section 227 of the code, has the undoubted power to shift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out, where the materials placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. The test to determine a prima facie case would naturally depend upon the facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him, while giving rise to some suspicion but not grave suspicion against the accused, he will be fully within his right to discharge the accused. That in exercising his jurisdiction under section 227 of the code, the judge, which under the present code is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence and the documents produced before the court, any basic infirmities appearing in the case, and so on. Stop.